All right, everyone, we are live. We are back for our afternoon session, so hopefully everybody is rejuvenated and had a good lunch break. So Raymond Martinez, we're back on your client. What is your client's name?
Robert Cavazos, Judge.
Robert Cavazos. Let me find him on the page. Yes. All right, Deputy Laura, Deputy Mejia, is there a Robert Cavazos in the courtroom?
No, Your Honor. He was here, but he came after everybody was out to lunch, and I did inform him to return back by 2 o'clock, and he's not here.
Okay, and what time did he come into the courtroom?
We were already out to lunch. It was like, I would say about 12:45.
All right. So, Mr. Martinez?
Yes, Judge.
If you want, I will give your client till the end of court today when we finish with all the other cases, if you want to see if you can get in touch with him.
Judge, I specifically spoke to his wife, girlfriend, who gave him the ride to the courthouse, and I was very clear that they had to be sitting in the courtroom at 2 o'clock. He's been hemming and hawing about it. I know he's got anxiety issues, Judge, and he's nervous and worried, but he knows what he's supposed to do. Obviously, he showed up at 12:45.
Okay.
So, do you mind if I do something, and if I need to get back on, I'd be.
All right. Or do you want to call this case now? Do you want to wait and come zoom back in?
I will zoom back in, Judge, if you don't mind. And if something happens sooner, well, he's going to go into custody either way. So you can.
Well, if you will zoom back in then by 3 o'clock.
Yes, Judge.
All right. We'll see you then. All right. Anyone else have their paperwork ready?
Your Honor, this is Matthew Brown. I sent mine in earlier, but I don't know if it's been made its way around.
All right, Mr. Pena, have you signed any paperwork?
Not this morning, as far as the video conferencing. No,
All right, so what
yet.
I'm going to do, I'm going to send you to breakout room number 3. Your attorney will meet you there and go over paperwork with you.
Okay.
Thank you, Your Honor.
You're welcome. To the clerks in the back, do you have any paperwork?
Yes, we just received Caballero.
I can't understand a word you're saying.
We just received hold on, Joe Cabrera. We just received the plea packet. That's it. No, we're not ready yet.
Well, everyone, as soon as I have the paperwork, then we will proceed. And Mr. Myrick, have you had any contact with your client?
On the phone right now, my legal assistant's talking to her, so I'll let you know in a minute. Yeah.
Okay. She needs to get here in this courtroom and she needs to be here before 3:30.
Yeah. Okay.
Thank you.
I think you were muted, Judge.
Thank you, sorry. David, Martin, and Joe Ray, can I see you in breakout room number 5, please?
Hey, Norma, is there a chance I can talk to a CTD prosecutor? Or Marcus, if you're available?
Doug, we have to wait till Judge comes because she's the host.
Oh, gotcha. Okay.
I'll text her right now. Hold on.
I called y'all's court to get the link, and my client is still trying to connect.
Okay, give me 1 second.
And in fact, there he is.
Is he on it? Oh, okay.
Yeah. Carlos. Hey, you're on mute, but that's okay. We're just waiting for the judge, and I'm going to ask to talk to a DA.
Okay.
Okay. Just
I
stay on
can't
mute.
hear you very well. I cannot hear you very well.
That's okay. Just stay on mute.
All right,
Can you hear
Mr.
me?
Campbell, who is your client? Is your client with criminal trial division or family violence?
Criminal trial.
All right, I'll send you to breakout room number 4. Could a criminal trial division prosecutor meet Mr. Campbell in breakout room number 4, please?
Thank you, Judge.
Yes, Robert?
Judge, can you put me in a breakout room with Mr. Cabrera to swear him in?
Well, not now. You
Joe Cabrera? If you'll go to breakout room number 6, please. And the clerk will swear you in. Will Brooks, is your client the Joe Cabrera?
Yes, Judge. That was Mr. Cabrera.
All right, we're swearing him in, and then we'll take up your case.
Thank you, Judge.
You're welcome. All right, thank you. All right, who's the prosecutor you're working with, Mr. Brooks?
It was Joe Ray, Judge.
All right, everyone, if you're not a part of this hearing, I'm gonna need you to please mute yourself. All right, Mr. Cabrera, if you could unmute, please.
Yes, ma'am.
Thank you. Court is calling 2021 CR 2913W, State of Texas versus Hoyle, Anthony Cabrera. If I could have parties announced for the record, please, for the state,
Joe Ray Garcia for the state.
for the defense.
Will Brooks, Judge.
All right, and are you Mr. Cabrera?
Yes, ma'am. It's Cabrera or Cabrera.
Okay,
However
don't
you
make
would
me
say.
roll the R's. I'm not good at that yet.
Yeah, a lot of people get confused with the R's.
All right, we're proceeding by video because of the pandemic. Any
Yes, ma'am.
objections from the state?
No, Your Honor.
Any objections from the defense?
No, Judge.
Mr. Cabrera, I'm showing you a document entitled Defendants Consent to Appear by Video. Did you
Yes,
review
ma'am.
that document with your attorney? Did you
Yes, ma'am.
understand it and did you electronically sign it?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review that discovery with your client?
Yes, we
ma'am.
did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cabrera, I'm going to show you a document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, ma'am.
Did you understand that you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand that your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Next, I'm going to show you a document entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, ma'am.
Next, I'm showing you a document entitled Information. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, I do, Judge.
State, are you proceeding on the information as presented?
No, Your Honor, we're not proceeding on the lesser included assault, bodily injury, family, Class A misdemeanor.
Any objections?
No objections, Your Honor.
All right, Mr. Cabrera, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with or were charged with was assault, family, choking, strangulation? That's a third-degree felony. A range of punishment is anywhere from 2 years in prison and up to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand that the state is proceeding on the lesser included offense of assault, bodily injury, family as a Class A misdemeanor? Did you understand that the range of punishment for that offense is anywhere up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 1 year in the Bexar County Jail and up to $1,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
We've discussed the matter, Judge. Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do, Judge.
Ms. Carrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault, bodily injury, family as a Class A misdemeanor. They're requesting a $1,000 fine. Recommend deferred adjudication. They will take in consideration County Court Cause number 657735. There's to be no contact with Kiana, Keyana, Sedberry, Sedberry, and there's an affirmative finding of family violence. My understanding is that the defense is opposed to the condition of no contact. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, it is, Judge.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Repeal. Did you review that paragraph with your attorney? Did you understand it and did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 2 years. There'll be 100 hours of community service restitution, the BIPP course, parenting class, and anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense of assault, bodily injury, family as a Class A misdemeanor. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
State offers State's Exhibit 1 and all its attachments.
No objections, Your Honor.
Mr. Cabrera, I'm showing you a document entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
Yes, ma'am.
Hello.
All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We can't, Judge. We waive our PSI.
All right, is there anything you want to say on behalf of your client?
Yes, Your Honor. First and foremost, I'm thankful for JR and for the court allowing us to get this resolved today. We were initially scheduled for something else, but thank you. And on behalf of Mr. Cabrera, Judge, he's a very young man. He's not had any criminal history prior to this. You get a sense of people when you talk to them, and he has not attempted to minimize the situation or the offense itself at all. There's been no excuses from him. His desire is to do better for himself and for his family, Judge. He is together with the complainant still. Of course, you can see on the violation report that he was arrested for a violation of protective order that's in place until April the 4th, I believe. So he's not having any contact with her. He's out of their residence, and certainly will respect the court's orders in that respect. But they do have children together, Judge. He has shown a propensity not to reoffend as far as an assault goes, Judge. In other words, they've been around each other without having another incident reported. He is ready and eager to do whatever the court asks of him to try and put this behind him and try and move on. But I'd invite the court to inquire with him. I think he's saying all the right things for what that's worth, Judge. And for those reasons, I'd ask the court to consider a no harmful or injurious condition with the complainant after that emergency protective order expires. And if not, would the court make some considerations in respect to his ability to parent and to do exchanges and things of that nature?
All right. Mr. Cabrero, is there anything you wish to say?
I take full responsibility for what I have done. I know that I was wrong for what I did. And I know that what I did, I'm going to take full action of what I've done. And I'm sorry for what I did to her. I'm trying to fix my own thing. I'm trying to get better and do better for her, for my kids to be able to see them. Like I said, I just want to be there for my kids. I want to be there to help her with my kids because I know that it's hard where she, with her family and stuff, and her not being able to work and stuff. I just, I miss her. I miss my kids. And I just.
Okay, let's not beat around the bush. When you say you're sorry for what you did, what did you do?
I did put my hands on her, hit her.
Why?
We were arguing, and it stuff happens, and
no, stuff usually doesn't happen. So why did you do it?
I was angry. We were both angry. We were both telling each other stuff we didn't mean, and it happened. I have no way of saying anything else. I take responsibility for what I've done.
Okay, here's the thing. I think that the best way to learn from mistakes is to stop saying words like "it happened." What is it?
I did put my hands on her, like it says. I'm not hiding it. I did what I did wrong.
Okay, let's stop trying to minimize it by saying I put my hands on her. What does that mean? I put my hands on her.
I pushed her off of me. I did put my hands on her neck, like it says in the thing. I did make her head hurt. I did with the,
Well, how did you make her head hurt?
Well, from where I pushed her, and from where I did choke her. I did my wrong in it, and I'm sorry. Like I've told her before when I did.
How old are you?
I'm 21, ma'am.
So both you and her are playing house. Y'all too young to be in a relationship, but you're there because y'all have children now. How many children do y'all have?
2.
And what are the children's ages?
2 and about to be 1.
All right. And while this was going on, where were the children?
The children were visiting their grandmother. They take every weekend we get a little break for us to have our dates and stuff, so we don't get frustrated with ourselves and everything. We take our dates, and they were spending time with their grandmother on the weekends.
All right. She's acting as though this is not the first time that you've been violent with her. From what I'm reading in the police report.
Yes, ma'am.
Because it says that the victim reported the defendant keeps hitting and choking her. So maybe I'm wrong in my interpretation of that, or maybe I'm assuming things, but that sounds to me as though this is not the first time that this has happened.
It is the first time that this has happened. And if you were to get a hold of her, she would tell you the truth as well. They probably got it wrong or something, but this was the first time. Like I said, we did have our fights in here and there, but we never put our hands on each other at all. I did seek going to church. I started going to church with her. We started seeking our pastor's like advice and stuff. Like I said, we go and if we have problems that are going on and we're upset with each other, we take it to our pastor. We go to church on the Sundays and we ask, like, can you talk to us, sit us down? Because we don't, I'm 21 years old, I have 2 kids. I have a lot of bills to pay phones, the kids stuff, and I didn't have a lot of money to go to like take it to family counseling. In other words, if not, I would have put myself in counseling with her. But instead of we took a different route.
Why isn't she working? Because you said she's not working.
Yes, ma'am. She isn't working because she stays home with the boys. My family, the way I was raised is the man takes care of the family hold, that's the way my father always raised me. I don't stop her from working. I just tell her, like, if you want to work, go ahead and work. We'll figure it out. But like, you don't have to work. I'd rather you be home taking care of the boys and taking care of our kids and taking care of our household. And I'll be the one to provide for us.
All right, just give me one moment. Joseph Acevedo, if you go to breakout room number 3, please, and Mr. Carrillo, if you'll go to breakout room number 3. All right, Mr. Brooks.
Yes,
I don't feel comfortable removing the no contact order until the complainant comes in and tells me. And I get a chance to talk to her and sort of get a read from her about what's really going on. So, Mr. Cabrera, for now, it's going to be no contact, but if your attorney wants to have that lifted, he can set a hearing for it, and then I'll reconsider, okay?
Yes, ma'am.
So it'll be no contact for now, but as soon as your attorney files the motion or wants a hearing for that, we will have that. And the 187th, our hearings occur rather quickly. So I'm sure, Mr. Brooks, if you file that, we could probably have a hearing by next week. Just get in touch with the court coordinator and she will do that. All right.
Judge, and before I forget, I don't know if whether it's value to the court, and I understand the court's order. She did not want to proceed on the case, which we have it's very common. Also, the circumstances of violation of protective order, they were in the park with some other people after hours, so it wasn't a call for some sort of emergency situation. And Mr. Cabrera had lost a family member recently, and the complainant sponsored that to the officer who was asking why they were there that hour. And he ran her name and saw the protective order in place.
Okay. All right. Just if you want to set it for next week, I'm sure we'll have room for it next week. Just let Norma know.
Thank you, Judge.
You're welcome. All right. So it will be $1,000 fine. That will be probated.
Each Febreze carbine clip.
Take in consideration County Court cause number 657735. There'll be no contact with Kiana Sedbury. And as I stated, Mr. Cabrera, I'll reconsider that once I get a chance to speak with her. There's an affirmative finding of family violence.
So how would you get a hold of her?
Your attorney will take care of that.
Okay.
All right. So there's an affirmative finding of family violence. 2 years deferred adjudication, the BIPP course. I'm going to request parenting classes. You must complete the parenting classes. If you complete them, then the 100 hours of community service restitution will be waived.
Okay, thank you.
You're welcome. Is there a reason we're doing BIPP in anger management? Or a request for both? One?
Just based off the facts that you read in the report, Judge.
Defense, do you think both are needed, BIPP and anger management? It's just that I don't want to overload him.
Sure. Judge, I think BIPP is obviously more extensive than the APSE course, but he was willing to do whatever was requested of him, if that makes sense.
All right, we'll stay with the BIPP. I don't want to overload you as far as conditions, because the court's main concern is, one, you need to learn how to handle your anger. I think that can be addressed at the BIPP course. Number two, you got to be a role model for your sons.
Yes,
So
ma'am.
you don't want them to think it's okay to do this.
No, ma'am.
So hence the parenting classes. And we'll do proof of employment within 15 days. My understanding, you already have employment.
Yes, ma'am.
There'll be regular Zoom reporting with probation. Are we going to have any drug issues with you, Mr. Cabrera?
No, ma'am.
No marijuana or anything like that either?
No, ma'am.
Okay, so make sure that continues.
Yes, ma'am.
And Rebecca, for him, it will just be regular UAs. And Mr. Cabrera, if there ends up being an issue with you taking the UAs because of your employment or busy schedule, Rebecca, it's okay for him to do the patch. It's only that the patch costs a little more, okay? But whether you want to do the patch or you want to do the regular UAs, that's completely up to you, Mr. Cabrera. All right, is there anything else you feel you need to be successful on this deferred adjudication?
No, ma'am. Can I ask what the UAs are?
Oh, that's where they do a urinalysis to see if you're taking any drugs or not.
Okay.
Judge, one thing that occurred to me, he does work construction, and sometimes the jobs are out of town. So if he can verify it, would he be able to work those jobs that require him to leave Bexar County?
Rebecca, does he need leave for that, or can he just do that?
If it's within the state of Texas, he can talk to his probation officer and they can give him a travel permit. He just needs verification from his employment stating that he travels outside of Bexar County for employment purposes.
All right, and I'll add defendant allowed to work outside of Bexar County.
Yeah, and if it's outside the state, of course, it's up to the court's discretion.
Yes, because we do work in Austin, Mississippi, Houston, Dallas, and stuff like that. We have where our company is located in all those areas, and sometimes they do send us out of there, out of San Antonio and stuff like that to go work.
This is what I'm gonna put. Defendant allowed to work outside of Bexar County and out of state for employment.
Thank you, Judge.
All right. And just let them know if there's a problem, contact your attorney. Your attorney will let me know if there's a problem with your being allowed to work out of county or out of state. Let me show you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, Mr. Cabrera, don't let the court down. I wouldn't have placed you on deferred adjudication if I didn't think you could do it, okay?
Yes, ma'am. Thank you so much.
All right, you're welcome. We're off the bracket, Brenna. Mr. Cabrera, you're young. Your children are young. Hopefully they don't remember anything about this, but you got to do better. Once you know better, you do better. You get angry, just walk away. Okay?
Yes, ma'am.
All right.
Is there any way I could talk to my have my attorney call me after this?
Yes. What I'm going to do, I'm going to send you to a breakout room, Mr. Cabrera.
Okay.
Let me see where you were. I'm going to send you to breakout room number 5. And
Okay.
Mr. Brooks, are you still here?
I'm still here, Judge.
All right, if you could go to number 5. And
Yeah.
Rebecca, if you could go to 5, and then you all are excused. You don't need to come back to the main room.
Thank you, Judge. Have a good day.
All right, thank you. You too.
Have a good day.
I think the certificate on this one is still in your inbox. So as soon as I get it back, I'll bring it up.
Okay, what is it?
They're both places.
What did you say is in my inbox?
The certificate.
Okay, I think I may have sent you.
Okay, probably come back.
All right, thank you.
Your Honor, just a little update on my client, Faith Sutherland. She just informed me a moment ago, she's on her way to the court. She said her ETA would be about 2:45 to 3. Is that right? 2:45? Yeah.
Judge, she just called Lupa and said that James Meyer had told her not to show up to court. And I'm just relating the message. And I told Lupa to tell her that she needed to show up to court before 3 or a bond forfeiture will be issued out. And she hung up on Lupa.
Okay. All right. We will see if your client shows.
Okay.
All right. We're going to take up Mr. Narvaez. And I'm sorry, just before we do that, Mr. Acevedo, what is happening with your client, Mr. Carrillo?
Judge, we are going to have a resolution, and I believe we're 90% the offer to be able to apply for probation. I was just telling the assistant DA that I'm just not feeling good right now, and I'm not up to doing it right now, but that is the plea that we're looking to apply for.
Okay, can you have your client come back to the main room, please?
Let's see.
Just go back to breakout room number 3 and tell them to come back.
Okay, hold on.
And Norma, on Mr. Narvaez, I think they say they're waiting on a trial court certification for me.
Yes, ma'am. I just, from you, let me.
I'm sorry, Norma, they say it just came in. And Norma, could you call Mr. Martinez and let him know his client is in the courtroom?
Yes, ma'am, I just did.
All right, thank you. And I'm sorry, Mr. Glenn, just give us 1 second.
It's all good, Your Honor. No problem.
And Norma, can you see on Mr. Carrillo?
Yes, ma'am.
See if we can call him back tomorrow to take care of this plea because he's in custody.
Yes, ma'am. Is Joseph going to be available tomorrow?
I think so. I mean, it's going to be set for tomorrow.
Okay, I'm going to chat to you real quick.
All right, he's in a breakout room.
Judge, I sent you a chat.
All right. Cornelius Cox. Miss Flanagan. If you can unmute, please.
There, am I there?
Yes, you're there.
Oh,
all right, Mr.
God,
Flanagan.
I know nothing about phones like this. This is my first time. I'm so sorry. You want me to call Cornelius and tell him to get his booty over there?
Miss Flanagan.
Yes.
This is what I want you. I want you to internalize what I'm saying, and I want you to think about it. And when Cornelius zooms back in, you can have an answer for me. Okay. So my understanding is that you're here trying to get off of probation early.
Yes, ma'am.
All right. So what I want you to internalize and think about is, why would the judge allow somebody to get off of probation early when they're on Zoom laying in bed? So I want you to internalize what I've just asked you and then just think about it and address it when Cornelius comes. All right, Joseph Acevedo,
Yes, Your Honor.
if you can unmute. All right, Mr. Carrillo, can you unmute for me, please? My understanding is there's some kind of agreement that's been worked out. We're going to recall. Just push, when you see the request to unmute, just push it, Mr. Carrillo. Mr. Acevedo, we're going to recall your case for tomorrow.
Tomorrow, Wednesday or Thursday?
Today is Wednesday, so we're going to call you tomorrow at 9 a.m. Please be here at 9 a.m. And if all the paperwork is done, we'll take you first.
Yes, Your Honor. Subject to feeling better, yes, absolutely.
All right, and if you want to bring someone else in to do the plea, just let us know. But we'll see you. Ms. Carrillo, we're going to bring you back tomorrow at 9 a.m.
Yes, ma'am, Your Honor.
All right, we'll see you there.
Your Honor, may I go to a breakout room with the prosecutor, please?
Sure. If you will go to breakout room number 1, the prosecutor will meet you there.
Thank you.
And Norma, if you can recall Mr. Carrillo, sorry?
Do I go also, ma'am? Your Honor?
No.
Okay.
Norma, if you recall Mr. Carrillo for tomorrow, please.
Yes, ma'am.
Am I done here, Your Honor?
Just give me a moment. We'll let you know if you're done.
Yes, ma'am. Thank you.
You're welcome. All right, we're going to go on Mr. Nervice and then Mr. Serene. Oh, Mr. Serene, I'm sorry, Mr. Gwen. Mr. Serene should be fairly quick and his client is in custody. All right, Mr. Serene, do you have all of the discovery or no?
No, Your Honor, I do not have all of the discovery. I have several witnesses that I have available under subpoena. Hold on one second, I'm sorry.
Okay, well, just one moment. Since you do have witnesses, just give me 1 second, okay?
Yes, Your Honor.
All right, who's the prosecutor on Nervice?
That would be Mr. Nesbitt, Your Honor.
Judge, I did the paperwork. I can do it unless Tom wants to.
Tom, are you available or no?
Oh, sure. I'll start on the dismissals, Tom.
All right, thank you. Mr. Nervice, can you unmute yourself, please?
Am I off mute?
All right, thank you.
Yes,
Court
ma'am.
is calling 2020 CR 2622 and 2021 CR 2914W, State of Texas versus Antonio Jesus Nervice. Could I have parties announced for the record, please, for the state?
Tom Nisbet.
For the defense?
Yeah, McGuinn, Your Honor.
Are you Mr. Nervice?
Yes, I am, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state or the defense?
No, Your Honor.
No, Your Honor.
Mr. Nervice, in each of these cause numbers, I'm showing you a document entitled Defendants Consent to Appear by Video. Did you review those documents with your attorney? Did you understand them? And did you electronically sign them?
Yes, ma'am. Fully to my understanding.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily consented to appear by video. Mr. Gwen, in each of the cause numbers, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery and did you review the discovery with your client?
I have, Your Honor.
Court will find in each of the cause numbers that the state is in compliance with discovery. Mr. Nervice, I'm going to show you a document entitled Waiver of Indictment, Reading of Information. and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure, and cause number 2021 CR 914W. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
Did you understand in that cause number, you have a right to have a grand jury hear the evidence in that case and make a decision on whether or not to indict?
Yes, ma'am.
Did you also understand that your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in that cause number?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And that cause number, I'm showing you a document entitled Information. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes. Information, yes.
And then in cause number 2020 CR 2622, I'm showing you a document entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
In cause number 2020 CR 2622 and 2021 CR 2914W, I'm showing you documents entitled Court's Admonishments. Did you review those documents with your attorney? Did you understand them and did you electronically sign them in all the appropriate places?
No, ma'am.
Yes, ma'am.
Right. And cause number 2021 CR 2914W, you're charged with the offense of theft $2,500, but less than $20,000 of a vehicle. And 2020 CR 2622, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. Each of those offenses are state jail felonies. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
In each of the cause numbers, if you have a plea bargain agreement, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand in each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Well, I was living in Odessa.
Did you understand by entering a plea bargain agreement in each of these cases, you were giving up those rights?
If I get out right now, I'm going to live with my father.
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
Yes, ma'am.
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
In each of the cause numbers, do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
In each of the cause numbers, do you believe he's currently competent and was legally sane at the time of the
I have
offense?
3
I do,
childhood
Your Honor.
friends that work in Odessa.
Mr. Narvaez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
In each of the cause numbers, has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
In each of the cause numbers, are you satisfied with the way you've been represented?
Look at the news.
Fully, ma'am.
In each of the cause numbers, are you a U.S. citizen?
Yes, ma'am.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
In each of the cause numbers, according to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There are no applications. The cases will run concurrently. In each of the cause numbers, the state will take in consideration the following NIMAC numbers: 580960, 580959, the following JN numbers: 198, 5843, and 1995646. Did you understand that to be a plea bargain in each of the cause numbers?
Yes, ma'am.
Defense, is that the plea bargain agreement in each of the cause numbers?
It is, Your Honor.
I'll help you, sir.
State, is that the plea bargain agreement in each of the cause numbers?
Yes.
You know, we till you come back.
Mr. Nervice, in each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney and did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that in each of the cause numbers, you were giving up your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motions?
No, Your Honor, there haven't.
Mr. Nervice, then, in cause number 2021 CR 2914W, to the information, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And in cause number 2020 CR 2622, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, in each of those cause numbers, do you have any evidence to support the defendant's plea?
The state offers.
Yeah, right. But
Any objections?
No objection, Your Honor.
Mr. Nervice, in each of the cause numbers, I'm showing you documents entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents in each of the cause numbers with your attorney, and did you understand them? And did you electronically sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand in each of the cause numbers, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Then in each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
all right. 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 Y'all see it as well. Yeah.
All right, in each of the cause numbers, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
In cause number 2021 CR 2914W, the court will follow your plea bargain agreement, sentence you to 2 years in the state jail facility, give you credit for any time served. This run concurrent with 2020 CR 2622. Take in consideration NITMAG numbers 580960, 580959, and JN numbers 198, 5843, and 199, 5646.
Yes, ma'am.
And cause number 2020 CR 2622. The court will follow your plea bargaining agreement, sentence you to 2 years in the state jail facility, give you credit for any time served. This will run concurrent with 2021 CR 2914W. Take in consideration NITMAG numbers 580960, 580959, JN numbers 198, 5843, and 199, 5646. Mr. Nervice, in each of these cause numbers, I'm showing you what's entitled trial court certification of defendants' rights to appeal. Did you review those documents with your attorney? Did you understand them? And did you electronically sign them?
Yes, ma'am.
In cause number 2020 21 CR 2914W, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because it is a felony conviction, you're not allowed to own or possess any weapons or ammunition.
473375.
And cause number 2020 CR 2622, because you reached a plea bargain agreement with the state, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, Mr. Nervice, good luck to you. We'll go off the record. Mr. Nervice, it appears that you may have a drug problem. If you don't get a handle on that, you're going to end up in and out of prison. Do you understand?
Yes.
All right, so let me ask you, the tattoos you have on your face, were those painful?
Right.
They
Yes.
were? All right. All right, Mr. Nervice, this is not the end of the road. You can still do better and change your life around, okay?
Yes.
All right, good luck to you, Mr. Nervice.
Thank you for everything.
All right, you're welcome.
Thank you, Your Honor.
Thank you.
May I be excused?
Yes, Norman, and can you let them know that 14G can go back?
Yes, ma'am.
Yep.
All right,
We're
done,
to
that's
the
all.
courtroom. I have Mr. Robert Lee Cavazos.
Yes.
Thank you, sir, for everything you did for me.
God bless you. I'm glad to. Have your wife call me or you talk to me after.
Call back and find out.
Or you call her and just said, I love her.
I will.
Thank you, boss. God bless everybody.
Thank you. Courtroom, is Mr. Cavazos there?
He said he was going to step outside to the hallway.
Ready to
They're
go to it?
no longer in the hallway.
All right. We're going to call this case. Where's Mr. Martinez?
I'm here, Judge.
Your client came to came to the courtroom, went in the hallway and left.
Judge, I would ask the court to issue a bond increase versus a forfeiture. He's obviously been there a couple of times today, but he's
Thank you, no, man, but I double checked.
not in his right
You
mind.
ever talk to anybody?
Oh, my lawyer was there.
All right. We're going to go on the record briefly. Is there a prosecutor available? Any prosecutor? Yes, thanks. All right, court is calling 2019 CR 10398, State of Texas versus Robert Lee Cavazos. Could I have parties announced for the record, please?
I'm Nisbet from the state.
For the defense?
I'm muted. No.
All right, this was scheduled for a sentencing at 9 a.m. The defendant, my understanding from the court, made his appearance at court at 12:45 p.m. Then he showed up closer to 2:45 p.m., came to the courtroom, and then he immediately left again, and no one knows where he is. Deputy Laura, is Robert Lee Cavazos in the courtroom?
Not at the moment, Your Honor.
And did you check the hallway for Mr. Cavazos?
Yes, I did.
And is he anywhere in the hallway?
No, he is not.
All right, state.
State asks that you issue a warrant and revoke the defendant's bond.
All right, defense.
Judge, we're not going to fight the issue of the warrant. We would ask that it be in the nature of a bond increase or a judge's warrant, whichever way you want to characterize it, in light of his apparent attempts to appear, but not fully complying and following through. I guess we should have asked. I guess I should have asked if he did appear to have the bailiffs, because I was worried that he was acting illogically and not in his own best interest.
All right. Yes.
He's at the hallway again.
Oh, Deputy Laura, if you could have him escorted into the courtroom, please.
Ma'am.
Good afternoon, Mr. Cavazos.
Yes, ma'am. Good afternoon.
Good afternoon. We're here today for sentencing. We're still on the record.
Yes, ma'am.
For the record, the defendant is in the courtroom. This is one of the days that the court could have in-person hearings. Is there any objection that the sentencing take place by Zoom? State?
Nope.
Defense?
Your Honor.
All right. According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. I'll follow your plea bargain agreement.
Yes, ma'am.
Previously, the court found you guilty of and found paragraph 1 of the enhancement true. The state waived the other allegation. Paragraph, court will sentence you to 5 years in the prison, give you credit for any time served. Take in consideration the following cause numbers. JN numbers 1963584, 1984951. Cause numbers 2020 CR 5274, 2020 CR 6577, County Court cause number 637319, cause number 2020 CR 7911. Mr. Cavazos, I'm showing you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you are not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, good luck to you. We'll close the record.
Thank you.
Judge.
Thank you. Are the parties ready on Andrew Pena?
Yes, Your Honor.
All right, who's the Mr. Brown?
Marcus.
Okay. Is this going to be a continuation of probation? Is that the agreement?
Yes, but not a full agreement.
Okay. All right. Court is calling 2018 CR 8244 and 2020 CR 8246W, State of Texas versus Andrew Eugene Pena. If I could have parties announced for the record for the state.
Marcus Sanders.
For the defense.
Matthew Brown.
All right, and are you Mr. Andrew Pena?
Yes, ma'am. Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No, Your Honor.
Mr. Pena, in each of these cause numbers, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor, I did.
Then in each of the cause numbers, the court will find that the defendant has knowingly and voluntarily consented to appear by video. Mr. Pena, in each of the cause numbers, I'm showing you documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review those documents with your attorney? Did you understand them?
Yes, I did, Your Honor.
Are you the same Andrew Eugene Pena who was placed on deferred adjudication in 2020 CR 8246W for the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams on October 21st, 2020 for a period of
5 years.
Just one moment, everyone. It appears that there needs to be just one moment. There appears to be an issue with the motion to revoke. Oh, no, it's nothing. Yeah. Okay. All right, thank you. All right. We're off the record, Brennan. All right, so in cause number 2020 CR 8246W, the plea paperwork makes this a second-degree felony. The judgment usually trumps everything. And the judgment says possession with intent to deliver 4,200 grams. Now, mind you, the judgment hasn't been signed by me. So I think the correct judgment should be possession of a controlled substance, penalty group 1, 4 grams to 200 grams. Have both parties had a chance to review that?
No, Judge, if you give me just a minute, I'll look up or I don't know if you have it in front of you, the original plea agreement.
Yes, the original plea agreement, according to the court admonishments, it's possession of controlled substance penalty group 2, 4 to 200 grams.
Yeah, Your Honor, I don't have that. I was not the attorney of record for the plea agreement. I'm sorry.
Well, what I can tell everybody is I'm looking at this. This is what it says. If you can, I know you're reading it backwards.
That's what it was.
If you all want, I can have the clerk scan this and send it to you by email.
Yes, that would be helpful, Your Honor.
All right, and it appears that a judgment was never signed, that it wasn't ever presented, so it has not been signed. So it will be easy to correct this if that's what it should be. And let me look at the second one.
That's what it was.
The second one is the state jail felony, so that's correct. So let me give this to the clerks to send an email to each of you with this in it. But I believe the judgment should be a possession case instead of intent to deliver, in which case it'll be a second degree as opposed to a first degree. So we're going to take a short break on this case and we'll get that email to you. Can you email this to them? All right, thanks. And I'll just set this aside for later. And if you could just email it probably to Marcus, unless you have Mr. Brown's email, and then he could send it to Mr. Brown. All right. Marcus, he'll send it to you, and then if you could forward it to Mr. Brown.
Yes, ma'am.
All right. And we have Cornelius Cox.
Let me get him, Judge.
All right.
Judge, while we're waiting, I had a chance to talk with Mr. Sanders about Mr. Vasquez and learned that there's an at-large theft case for Mr. Vasquez that I asked Norma to assign me if that was okay.
Ask for what? I'm sorry.
I asked her to assign me to his at-large.
Oh, sure.
And I don't have a motion on file because obviously I didn't know about it, but if the court is willing to give him a PR bond on that also, that might be helpful in moving this case ahead.
All right, if you'll confer with the state on it.
Judge, he'll need to be magged on it. He's a fugitive on the new case.
Okay. All right, if you'll confer with the state on the bond, and then we'll magistrate on him. Mr. Cox?
Cases. All right, Ms. Bendis.
Okay.
You know.
All right, Mr. Cox, we have a problem with your client. Oh, you're muted, Mr. Cox. Angel, he's muted.
Judge, he was taking care of a plea in the 175th, Judge. That's probably why he's muted. He was finishing up a plea.
Oh, well, if he wants to finish up the plea there, Angel, just let him finish up the plea there. His client is going to have to appear in court because she's.
Tell him, Ray, you can't unmute me.
Yeah, I am.
Judge, can you hear me?
Yes, I can, but here's the problem with your client.
Well, I know she's lying. She's in a bed, but she was attacked by a pit bull.
Oh, no. Here's the two cardinal sins she has committed. One, she's laying in bed. Two, I understand people have been attacked by pit bulls or whatever. Okay, fine. But the next thing she did was she was smoking on screen. And I will not have that.
Oh.
So, I mean, that's where we are. So if she wants to appear in court to have me hear her motion, I will be more than happy to hear it with her presence in court. But I don't know why people think that you can smoke on screen. Heck, I'd like to be eating a sundae with pecans on top and some whipped cream, but I can't do that. You know why? Because I'm in court. I would love to be laying in my bed having court from bed. It would be relaxing. Maybe getting a pedicure or manicure while we're doing court, but I don't, because that would not be professional. So I don't know why she would think she could lay in bed plus smoke a cigarette after I've already admonished her about laying in bed. So that's where we are.
Okay.
So she can show up to court and I'll hear her motion.
Okay. So that admonishment will not suffice. It wasn't that good admonishment. I even feel, I even feel more professional now since I've heard it.
Well, but you know what the problem is, Cornelius, you're already always professional. You're in suit and tie. So yeah, but I'd already told her.
Okay. Can we tomorrow? Oh, can we do it tomorrow then?
Oh yeah, she can come to court tomorrow.
Okay. Do you want us to come in the afternoon or in the morning?
Do you have witnesses?
Oh no,
In the morning.
In the morning.
Okay, no, Miss Flanagan, it'll be the afternoon.
Well, my husband, he travels, he picks up the handicapped kids, and that starts at 1, but he can be there with me in the morning.
You mean the children with physical disabilities? That is who he's picking up?
Yes. And that's what we do.
Well, it can't be tomorrow then.
No, it can. He gets back. He gets out.
No.
It can't be tomorrow, because you're telling me you can't do tomorrow afternoon. And see,
I'm trying to tell you that he doesn't go in till 1 o'clock.
So what you want us to have a court hearing at
in
noon
the morning
for you because you are laying in bed and smoking?
No, ma'am.
Our morning docket is already full. We're not adding you to our morning docket.
Okay. So if we can't do it tomorrow afternoon, can we?
He said we can have him on video on the phone if you'd like, because we have that capability with our phones.
Here's the thing, you guys can go to a breakout room and discuss whatever you would like to discuss. We're going to move on to the next case.
All right.
Okay.
And then I'll inform your coordinator, Judge.
All right. I sent you to breakout room number 1, Cornelius.
Thank you, Judge.
You're welcome. And Ms. Ferguson, if you could go to breakout room number 1. James Meyer, your client is now in the courtroom.
Great, I'm here, and you're right. I'm ready when the court's ready.
All right, could I have a courtroom? Could I have Faith Aaron Sutherland Trevino? Is she dressed appropriately, court, without a do-rag on her head?
Yes, ma'am. Closer.
All right, who's the prosecutor on this?
Right here.
Marcus.
Right.
Okay. Announcements? Yep.
Court is calling 2021 CR 0666, State of Texas versus Faith Aaron Sutherland Trevino. Can I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
James Merritt for defendant.
We're proceeding by video because of the pandemic. Any objection?
No objection.
None.
Court will note for the record that the defendant is in the courtroom. This is one of the days the court is allowed to have in-person hearings. Ms. Trevino, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it? Did anybody hear something? Because I didn't.
No, Judge.
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, and I have reviewed it.
Court
And
will find-
I've received everything.
Court will find that the state is in compliance with discovery. Ms. Trevino, I'm showing you a document entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney, and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge. Yes, Judge.
Mr. Trevino, I'm showing you a document entitled Court Admonishments. Did you review those documents with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
I cannot hear you. Yeah?
Okay, first of all, it's not yeah, it's either yes or no. Second of all, could you get into a stationary position and stop the swaying back and forth?
I said yes, ma'am. I never said yeah.
No, you said yeah, because the court reporter has taken down everything that everyone is saying. So in this courtroom, it's either yes or no. Do you understand?
Yes, ma'am.
What you're charged with is unauthorized use of a vehicle. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow the plea bargain agreement. If for any reason the court does not follow the plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them, the right to remain silent?
I didn't hear.
Nobody heard her.
Yes, ma'am.
Did you not speak up? Is there an issue?
Oh, I said yes, ma'am, like 3 times.
No, you didn't. And here's the thing. You need to speak up and you need to stop swaying. Do you understand?
Yes, ma'am.
You were on this Zoom yesterday talking about do-rags were a part of Black culture. Well, let me just tell you this. Swaying, not saying yes or no, that's not a part of the Black culture. That's just you doing silly things while you're on Zoom, and the court will not be tolerating it. Do you understand?
Yes, ma'am.
So again, do you understand that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Trevino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Next, I'm going to show you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is requesting a $1,000 fine, recommending deferred adjudication. There's to be no contact with Shakira Baker, S. Shukria or Shukia? Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver Appeal. Did you review that paragraph with your attorney and did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, ma'am.
Counselor, are there any such motions?
No motions are in file.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 120 hours community service, restitution, and CATS 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea.
Yes, the state offers State's Exhibit 1 and its attachments.
Any objections?
No objection.
Ms. Trevino, I'm showing you a document entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, ma'am.
Did you understand that today the state is presenting evidence in the form of witnesses' statements and police reports, but most importantly, that there will be no live testimony? Did you understand?
Yes, ma'am.
Court would find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court will review the same.
Yes, ma'am.
After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
No objection to that. We hope so, yeah.
Anything you wish to say on behalf of your client?
Well, in the fact that she's really on her own and she's doing her best. I think she just has to be careful of the company she keeps, but she doesn't have, to my knowledge, alcohol or drug issues at this time. Perhaps a little bit of some mentoring would be helpful for her in obtaining stable employment.
Ms. Trevino, how old are you?
I'm 18.
If you're drug tested today and know you're going to be drug tested today, what are the results going to be?
Positive.
For what?
Marijuana.
And what else?
That's it.
Who are you living with?
Myself.
How far did you go in school?
I dropped out 9th grade.
Why?
Because I just was going through things and I wanted to make my money.
All right. So dropping out of school, I think we can put a checkbox by that's not a part of the Black culture.
I'm going back, so.
Well, going back and going back are two different things. You're not going back. You're not there.
I am there. I got my computer. I already went back. I go to CAN.
What did she just say? I have no idea.
It's off topic anyway. That's off topic.
Okay, see, I think this is what you don't understand. As a condition of your deferred adjudication, I can have you taken into custody, and then you can get on topic at the Bexar County Jail. Whatever question I ask you is on topic.
I go to school, so I answered your question.
What did she just say? She will not
I said
open her mouth and speak so that somebody can understand her. Again, that's something that's not a part of the Black culture, where we can't understand what each other is saying. So where are you at in school? Since you're saying you go to school.
9th grade.
Where are you attending school?
Texas can.
What is your answer to that question?
Attending San Antonio Pan.
How long have you been there?
I just started this year, so probably like, I think I've been at Can 3 months.
How are you supporting yourself?
I'm getting unemployment and make money moves. My hustle is worth that. That's how I pay my bills.
Hustle is where
side jobs. I do side jobs to pay my bills.
Okay, let's back up a little bit. First, you're saying you make money moves. Don't know what that is. And then you say you're hustling. What do you mean by hustling? What exactly are you doing?
I sell body wash, I sell makeup. I do like electronic stuff on the side with people, that type of stuff, like side jobs.
Where are you getting makeup from to sell?
I got connects. My girlfriend. She gave it to me and I said it.
You got connects. Here's the thing. People, could we all pretend, even if it's not true? Let's pretend like we have formal education, that we've went to school. And let's stop using slang. Let's start speaking in complete sentences. And every complete sentence must have at least 2 things, a noun and a verb, at the very least. So let's try doing that, and let's be better.
I could hear you, but you're talking really low.
You're going to get a job. If you're living by yourself, you need to be employed.
Get a job, well, because right now I'm getting unemployment. I've been having issues with the unemployment, so that's kind of been an issue. So I'll probably end up back with a physical job like McDonald's, for example. And that's
no, I mean, what I'm telling you is you are going to have a job.
Oh, yeah.
Collecting unemployment means, the very definition of it means you don't have employment because you're unemployed. And the 187, you're on probation, you will have employment.
Mm-hmm.
That's going to be $1,000 fine. No, I'm not probating it. 2 years deferred adjudication. There's to be no contact with Shakira Baker. And who are these people you were with in this vehicle?
My friends and my siblings.
Okay, who is Abel Ramos?
That's my friend.
All right, who is Nathaniel Mejia?
That's also my friend.
Who is Priscilla Salazar?
I think that was Nathaniel's chick or whatever.
Who is Amber Rocha?
She's a friend.
And who is Jennifer Rocha?
She's a friend.
All right. 2 years deferred adjudication. There's to be no contact with Ms. Baker Abel Ramos, Nathaniel Mejia, Priscilla Salazar, Amber Rocha, Jennifer Rocha, and Sharon Riles. There's to be weekly Zoom reporting or in person until further notice. Proof of employment within 30 days. And Rebecca, it needs to be a real job where she's getting a real paycheck and paying real taxes. 120 hours community service restitution. CATS 1 and 2. I'm going to want field visits at least 2 times per month at wherever she's staying. And I want it to be random. I'm going to want a UA tomorrow by 3 p.m. And Rebecca, if that UA turns up more than marijuana, then I want her in intensive outpatient treatment. If it's just marijuana, continue to test and see if the levels go down. If the levels go up, she's going to intensive outpatient treatment. Rebecca, is there anything else she needs?
No, ma'am.
Showing you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Do you understand?
You say yes?
Yes, ma'am.
I'm gonna send you to a breakout room, courtroom.
Yes.
If you can go to a breakout room, let me find you on the screen. If you go to breakout room number 2, please.
Yes, ma'am.
And James Myron, if you go to number 2 with your client and remain in there until she's gone over conditions with probation.
Will do.
Thank you.
Judge, are you ready for me to go over there now?
Yes.
Or okay.
Yes, if you go now, please. Megan Enriquez.
Yes, Judge, I'm here and we're ready for the plea on Tracy Gomez. I believe all the paperwork is in. I don't know if you have everything.
I don't have any paperwork on Tracy Gomez yet. Let me send you to a breakout room.
I haven't received the plea packet. I haven't signed anything.
Okay, so if you're going to a breakout room with your client and see if she's signed anything, I'll send you to breakout room number 3.
Thank you, Judge.
Doug Campbell.
Yes, Judge.
Yes.
I had an opportunity to talk with Mr. Sanders through the chat. He is okay with, or at least the state is okay with the PR bond for Mr. Vasquez on his other case, which is 2021 CR 20.
Is your client in custody?
No, he's on a PR bond in his other case that I was aware of and appointed on.
All right, so where is your client?
He was here.
Carlos Vasquez?
He's still there.
All right,
Carlos.
what is the new charge?
I believe the new charge is theft also. It's a sealed case because it's at law.
Yes, I'm here. I'm here, Your Honor. I'm here, Mr. Doug.
Okay.
Well, if it's sealed, I can't give him a PR
Right.
bond until it's unsealed.
Right.
And I can't even give him magistrate's warnings until it's unsealed.
Great. Okay.
I don't know if it's still sealed. He's been indicted, but I guess I can ask him and look into it.
Okay, once that's done, then I can give him a magistrate warning and we'll go from there. Cornelius Cox?
On the ag assault?
No, it's a theft enhanced.
Judge, meanwhile, I because of this new case, I'm going to need at least 30 days to review everything.
All right, sure. We will make that happen.
Thank you.
Just give us a moment. Cornelius Cox, you're still here?
Yes, ma'am. I wanted to talk to your coordinator.
just so she can tell me whether it's going to be is it going to be tomorrow afternoon or tomorrow morning? I just need to know.
Oh, it's
On
not going to
Lisa's
be
plan.
tomorrow morning.
Okay, tomorrow afternoon. Okay.
Well, I mean, have you cleared that with Nora? Because she knows the
Oh,
schedule better than I do.
yeah. So I just need to. If you can send me to. I need a breakout room with Norma, or I can call her.
You can,
Oh.
if you can put it in the chat box, because Norma
Okay.
is the person who's in charge of the court's calendar.
Okay. All right. Thank you, Judge.
You're welcome. All right, Matthew Brown and Marcus Sanders, have you had a chance to review the documents?
I see.
I have not received that document, Your Honor.
All righty. Brenda, I think I jinxed us by saying, let's not make the Wednesday turn into a Monday. It is slowly trying to turn into a Monday. All right, Cornelius Cox, Norma Ferguson said tomorrow afternoon. All right, so if you want to go back to breakout room number 1, you can, and let your client know. And Marcus Sanders, if you've received the paperwork on Mr. Andrew Pena, could you please forward it to Mr. Brown?
Yes, Judge.
Thank you.
Robert, can you confirm that you received the paperwork now when you have a chance? Thank you.
If you go back to the breakout room, I'll send Robert to that breakout room and he'll let you know. So Robert, if you could go to breakout room number 3, please.
With 3? Okay.
Okay, thank you.
Judge, on the other case, they said that it's not sealed, and so the clerk should be able to see it.
Okay. And the paperwork on Miss Gomez just came in my box. All right, everyone, just give us all a moment.
Marcus.
Yes.
Hey, is the reason I can't see it because he has an active warrant?
I think so.
Okay. So if the judge were to set a PR bond, then he could just go turn himself in essentially and get booked and then released, right?
I'm sorry, say that again.
If the judge were to set a PR bond for him, in theory, he could just go down, turn himself in and be released after he's booked for it.
I don't know.
Doug, call Lupe real quick.
Okay.
Do you have his number?
Yes.
Give it to me. I'll call him. 335.
2517.
Thanks.
It's also your desire to enter the plea today to waive your right to jury trial. Okay, thank you. You can go ahead and lower your hand down now. And we should be good to go. I will put the
Everyone, the court reporter has taken a short break. As soon as she comes back, we'll take up, Brenna, I called your name and I didn't even call your name 3 times and you appeared. All right. So we're going to take up Tracy Gomez. Everyone, I appreciate your patience today. So who are the prosecutor on Tracy Gomez?
It was Jordan Brown, Judge.
All right, let's see where Jordan is. Yep, he's here. Your client's still in the breakout room?
Did she
Yeah,
not?
she is. Can you go back to breakout room number 3 and tell her to come to the main room, please?
Sure.
All right, thank you.
We're back, Judge.
All right. Ms. Gomez, if you can unmute yourself, please.
Ms. Gomez, you're on mute.
I thought I unmuted. Sorry, Judge.
No
Tracy,
problem.
go. Yes.
Court is calling 2020 CR 12248, State of Texas versus Tracy Gomez. Could I have parties announced for the record, please, for the state?
Jordan Brown for the state.
For the defense?
Megan Enriquez present for John Kuntz for Tracy Gomez.
Are you Miss Tracy Gomez?
I am, Your Honor.
All right, do you have any objection to Megan Enriquez standing in for John Kuntz?
Not at all.
All right, we're proceeding by video because of the pandemic. Any objections from the state or the defense?
No objection from the state.
No objection from the defense.
Ms. Gomez, I'm showing you a document entitled Defendants Consent to Plea by Video. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, I did.
Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Gomez, I'm showing you a document entitled True Bill of Indictment. Did you review that document with your attorney, and did you understand it?
Yes, Your Honor, I did.
Counsel, do you waive the reading of the indictment?
Yes, we do, Judge.
State, are you proceeding on the indictment as presented?
No, Judge, we're waiving the child passenger under 15 language, bringing it to a Class B misdemeanor.
Any objections?
No, Your Honor.
All right, I'm showing you a document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you have a chance to review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you
Your Honor,
understand? Yes.
If I may, under the offense level, it said FS as in state jail felony. I wanted to correct that for the record that it is going to be a Class B misdemeanor.
Yes, Judge, we discussed that. The state has no objection if the court's able to make that
And as
change.
you can see, it's been changed to Class B.
Thank you, Judge.
Great,
All right.
thank you, Judge.
No
Thank
problem.
you.
Did you understand the state is proceeding on the lesser included offense of driving while intoxicated as a Class B misdemeanor? Range of punishment for that offense is up to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, I do, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, she has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I believe she is.
Ms. Gomez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, I have.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, I did.
According to the plea bargain agreement, state is proceeding on the lesser included offense of driving while intoxicated as a Class B misdemeanor. They're asking that your punishment be assessed at 180 days in Bexar County Jail. There's a $1,000 fine, no application for deferred adjudication. They recommend community supervision. Take in consideration night mag number 580862, ignition interlock, DWI intervention, DWI repeat offender program, DWI VIP, 1 year Texas driver's license suspension. Did you understand that to be the plea bargain agreement?
Yes, I did, Your Honor.
Defense, is that the plea bargain agreement?
Yes, Your Honor, if I may, because she is part of the agreement is a 1 year Texas driver's license suspension, we'd ask that in lieu of the ignition interlock, she have some other sort of alcohol monitoring device since she won't be driving.
The court will consider that after she provides an affidavit of non-driving.
Yes, Your Honor.
I'm going to go along with what the plea bargain agreement is. And if you all have a different agreement that you want to reach later as far as whether or not it's ignition interlock, because according to this plea bargain agreement, you all have agreed to ignition interlock.
Okay, no problem, Judge.
Right. Next, I'm showing you the paragraph entitled Waiver of Repeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, Your Honor.
Do you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there have not, Your Honor.
And again, Ms. Gomez, did you understand the plea bargaining agreement as I read it? Did you understand that to be the plea bargain agreement?
Yes, Your Honor, I do understand.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation of 140 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense of driving while intoxicated as a Class B misdemeanor, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the plea?
Yes, Judge. State offer states Exhibit 1 and attachments.
No
Any
objection.
objections? Ms. Gomez, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, Your Honor, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and court has reviewed States Exhibits 1 and attachments. The court will find there is sufficient evidence of guilt, and the court will find you guilty of driving while intoxicated as a Class B misdemeanor. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
I have no doubt that she will successfully complete everything that the court is imposing as a condition of her probation. We're very grateful to the state for their consideration, and she's been very helpful in her defenses and in helping us negotiate with the state.
All right, the court will sentence you then to 180 days in the Bexar County Jail, suspended and probated for 2 years, $1,000 fine that will be probated, taking consideration night bag numbers 580-862. There's to be ignition interlock. And state, how long are you requesting ignition interlock?
Judge, we would leave that up to the court, and we would have no objection to an alternative should the affidavit come in a timely manner. It's not statutorily required, either of the previous indicted offense or the offense she pled to. Just based on the overall history and assessment of the case, we felt it would be an appropriate decision at the discretion of the court.
All right. Then the court will sentence you to ignition interlock for half the term. Or if you provide an affidavit of non-driving, then Rebecca, she can have an alternative to ignition interlock, whichever I guess is the least expensive one, either Scram or PAM or whichever one is least expensive. DWI intervention, DWI repeat offender program.
Judge, I believe those two are the same program.
What, Scram and PAM?
No, the repeat offender and the DWI intervention.
I'm unsure. It's just, this is what they have as a part of their agreement.
Whatever statutory required of a second TWI would be what we'd ask for, Judge.
Okay. Well, Rebecca, I don't want her to do twice. So just either
I'll
one.
put it in parentheses. I'll add it just to make sure.
All right. Thank you. DWI VIP, 1 year Texas driver's license suspension, proof of employment within 30 days, 90 hours of community service restitution, and outpatient treatment with probation. And there's to be a regular Zoom reporting with probation. And random UAs. Rebecca, is there anything else she needs?
No, ma'am.
Miss Gomez, is there anything else you need to be successful?
I just I feel bad that I'm here today. I'm sorry. I'm getting nervous and stuff. I just
There's no need to be nervous here.
I understand, Judge. It's just I feel guilty because I'm a single parent to my daughter that has special needs, and I would never do anything like that again. And I was 24/7 with her at home, and I just went to go get something to eat, and I just feel really bad that I'm with her so much. We had to get fresh air, and this occurred, and I walk with guilt every day. My first DWI was because my mother died, and I tried to kill myself a long time ago. That was 10 years ago. I never thought I would be in front of you or any judge for a situation like this, and especially when my child's involved. I have learned, but I'm upset. I'm disappointed in myself, and I barely got a job. I started working a few months ago. I was, like I said, I was a 24/7 parent with a little girl with Down syndrome, and I'm blessed that the ADA gave me a chance, and as you as well. Thank you.
You're welcome. And Ms. Gomez, life is all about learning lessons. If you make a mistake, you learn from it, you don't repeat it.
Yes, ma'am.
That's all any of us can do, because life is a journey, and it truly is a journey. And it's a journey where you're constantly learning.
Yes, ma'am.
So just take this as a lesson learned, and it won't happen anymore, okay?
Yes, ma'am. Thank you so much.
You're welcome. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, make sure you stay in contact with your probation officer. If there are any issues, contact probation.
I have a question.
Yes.
I've been reporting every week. I've never missed reporting every week. Do I continue to do that, or can I go monthly?
Probation will tell you what the conditions are.
Okay.
All right.
Thank you
All
so
right.
much.
You're welcome. I am going to send you to a breakout room. Let me see where you were.
3.
Breakout room number 3? Yes. All right, I'll send you to breakout room number 4 with your attorney. Probation will meet you in breakout room number 4 and go over conditions with you, and then you and your attorney are excused.
Okay, thank you so much, Judge. You have a great day.
All right, thank you. You too.
Thank you, Judge.
All right, and are we ready on Mr. Brown's case, Mr. Pena?
Yes, Your Honor. I've had an opportunity to review that pretrial agreement.
So is it, the court did not sign the judgment on that case. So it's a matter, it would be a matter, I think, of the state correcting that judgment, and then I would sign it. So this one should actually be, well, actually I can just do this, right? There we go. Okay, and so it's a second degree.
Yeah, actually, I can just go and actually just redo the front.
Okay, great. All right, so does everybody agree that it's supposed to be a second degree felony?
Yes.
Yes, Judge.
Well,
Yes.
not you, Mr. Pena.
Sorry.
I mean, I know you're hoping it's going to be a second degree felony. Although I think everyone has knowledge to give, but I was asking the attorneys. I was asking the people who went to law school to see if there's an objection, okay?
My apologies, Your Honor.
Oh, no need to apologize. I mean, I say, if you think it should be something, put it out there.
Yeah, I'm on my way. I want to say one thing. I'm on my way to law school as well. I should be there in about 2 years. Third year marshal.
Well, here's the thing. I don't want to step on anybody's dreams. But what I can tell you, for everyone who has criminal cases pending, any occupation that requires you to have a license They do a background check. That's an FBI background check. So anybody who before you go spending all the money to go to nursing school, to go to law school, to become a teacher, you probably want to do a little background studying to see whether or not you can achieve your ultimate goal. Not stomping on anybody's dreams, just throwing that out there.
Okay.
So are we ready on Mr. Pena?
Yes, we're ready, Your Honor.
All right.
We did have Mr. Sanders. I'm not sure.
Oh, he's here.
Okay.
And Mr. Campbell, Mr. Serene, I appreciate your patience today.
Oh, you got me excited, Judge. I took myself off mute.
Now it's just me saying, I appreciate your patience. All right, we're going to go back on the record in 2018 CR 8244 and 2020 CR 8246, Texas versus Eugene Pena. And so, in cause number 2020 CR 8246W, is there an oral motion to change the motion to enter adjudication of guilt to reflect that it's possession of a controlled substance as opposed to possession with intent to deliver?
Yes, Judge, we would ask that you make those changes.
All right, is there any objections from the defense?
No objection, Your Honor.
All right, Mr. Pena, in that cause number,
I'm
Mr.
sorry.
Brown, is that your dog?
That's my beagle, Your Honor. I'm sorry.
Oh, well, I guess he's like, I want some attention. All right. So, Mr. Pena, you have every right to ask for a continuance because that has been changed in the motion to enter adjudication of guilt. Do you wish to proceed or do you wish for a continuance?
I don't know which was better. I'm hoping to maybe get a bond.
Nope. Here's the thing.
Okay, that's all. I was just asking.
No.
So what do we have to do?
This is the thing about being an attorney. If you want to
Right.
be an attorney, you have to listen to the question and only answer the question that's asked of you. So, do you wish to proceed with this hearing, knowing that that has been changed, and actually has been changed to your benefit, or do you wish for this case to be reset for another day?
No, I don't want to continue with this hearing, Your Honor.
All right, in defense, do you wish to continue?
Yes, I do, Your Honor. Thank you.
All right, then, Mr. Pena, in each of these cause numbers, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review those documents with your attorney and did you understand them?
Yes, Your Honor.
And cause number 2020 CR 8246W, are you the same Andrew Eugene Pena who was placed on deferred adjudication for the offense of possession of a controlled substance? Penalty group 2, 4 to 200 grams. Is that you?
Yes, Your Honor.
And are you the same Andrew Eugene Pena who was placed on deferred adjudication in 2018 CR 8244 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on October 21st, 2020 for a period of 2 years? Is that you?
Yes, Your Honor.
State, are you proceeding on the same allegation in each motion?
We are, Judge.
Defense, is there any objection to the state reading one allegation and that allegation your client answers true or not true for both motions?
No objection, Your Honor.
All right, state.
Condition number 2, on or about the 22nd day of January 2021, in Bexar County, Texas, the defendant, Andrew Eugene Pena, did then and there illegally use a controlled substance, namely amphetamines, in violation of condition number 2.
How do you plead to that, true or not true?
True.
We'll waive the rest.
Any objections to the state's waivers?
No objection.
All right, Mr. Pena, did you understand by pleading true to violation of condition number 2 in 2018 CR 8244, the court could find it true, grant the motion, sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor, I
Court
violated.
will find violation of condition number 2 true, and that cause number. And cause number 2020 CR 8246W. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, sentence you up to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true, and that cause number. Is there an agreement?
Partially, Judge. We are both in agreement that we're asking that you deny our motion. The state's recommendation is probation's recommendation, which is to continue him, but transfer him to dual diagnosis residential while he's in custody. They are also asking that the condition be amended for ISP supervision, allowing for monthly office visits, home visits, UAs, and an imposed curfew.
All right. Defense, what are you requesting?
Your Honor, Mr. Pena would request to be, he's been in Laurel Ridge before. He would ask to go either back to that facility or to a veterans treatment facility if possible, and if the court has that authority to order such.
All right, so here's my question. I see where I ordered him to be transferred to Veterans Treatment Court. Did they not accept him?
He was not admitted.
Okay.
Oh, okay. I thought it was. Okay. I'm sorry.
So they're asking for dual diagnosis residential, Mr. Pena.
Yeah, and that's Laurel Ridge. I was there for my dual diagnosis. The day that I got arrested is that day I came home from there. I was there for 2 weeks. I want to go back for a month if I can, until the VA opens up for a longer period.
All right, see, this is the problem, Mr. Pena. It's
Okay.
just that you're leaving locations and you're not allowed to. What I'm going to do is I'm going to deny the motion. So I'll follow your agreement to do that. I'm going to alter and amend conditions. And what I'm going to do is I'm going to partially follow probation's recommendation. So there will be dual diagnosis residential, followed by ISP, and also I want him referred to felony drug court. And this is he's to remain in custody until felony drug court accepts him or he's placed in the dual diagnosis residential facility. Mr. Pena, you will not be released. You will be in custody while you're waiting these evaluations. Felony drug court, their evaluation should be fairly quick, probably sometime next week. If felony drug court does not accept you, then you will be placed at the dual diagnosis residential facility. Do you understand?
Yes, Your Honor.
Mr. Pena? You've got to
Yes.
do better. If you don't do better, you're looking at 20 years in prison.
I know, Your
I mean,
Honor.
if you get 20 years in prison, everyone will know where you are.
I know that.
All right, we'll close the record. And I'm going to send you to a breakout room, and probation will go over conditions with you.
Okay.
I'm going to send you to breakout room number 4, Mr. Brown. You can go to number 4. Just be patient. Once she finishes going over conditions with Ms. Gomez, then she'll go over conditions with your client. If you want to be with him in there, you can. If you want to leave, you're more than welcome to leave.
Yes, Your Honor. Thank you. Sorry about the dog.
No problem. Everyone just give, no, that's fine. Isn't Snoopy a beagle?
I believe so.
How can you be mad at Snoopy?
Oh, you can't. And it was just treat time, so it's okay.
There you go. It's like, I thought I had you trained better than that.
Exactly.
All right. So, Mr. Pena, if you go to breakout room number 4, please.
Okay.
And everyone, just give me 1 second to let Rebecca know what the conditions are, and I'll be right back.
How do I do that?
Brennan, I sent you an email.
Mr. Pena, if you look
Yes.
at
Got
the
it.
top
Thanks,
of your screen, there should be 4 squares right above breakout room. Click on.
Okay. Okay. I got it.
You got it? Good.
Norma,
Yes, ma'am.
on Mr. Pena,
Yes, ma'am.
can you have him come back in 20 days so we can make sure that he's just not still at the Bexar County Jail?
Yes, ma'am.
All right, Doug Campbell, on your client.
Yes, ma'am.
He's in custody. Yes. Okay. All right, so your client is Mr.
Vasquez.
Vasquez. What is his new case?
His new case is another theft case, and Carl came in and told me I was using the wrong term, despite the fact that I can't see it.
Oh, I'm sorry, I can't hear you.
He's a post-indictment fugitive.
Okay, so what is the cause number?
It is 2021 CR 2691.
And the charge?
I think it's a theft enhanced, theft less than 2,500. I can't tell you.
All right, let me see if state.
That's correct, Judge.
So what is it? Theft enhanced?
Theft under 2,500 enhanced.
All right, Mr. Cavazos. I'm sorry, Mr. Vasquez.
Yes, ma'am.
All right, on 2021 CR 2691, I'm going to tell you what the warnings are, the magistrate's warnings. I don't know the facts of your case. I'm just here to tell you what you're charged with and what your rights are. Do you understand?
Yes, Your Honor.
All right, you're in cause number 2021 CR 2691. You're charged with theft enhancement under 2,500. You have a right to remain silent. You have a right to hire an attorney or have one appointed to you. You will only be given a court-appointed attorney if you are indigent and you cannot afford to hire an attorney. You will have a reasonable time and opportunity to talk to or consult your attorney. If you decide to have an interview with any police officers or parties from the state or the DA's office, you can have an attorney present with you. You have a right to stop or terminate that interview at any time. You're not required to make any statements, but if you do make any statements, those statements can be used against you. If you're a foreign national, you have a right to access your consulate. If you decide you need a court-appointed attorney, a clerk will help you if needed, fill out the form so that you can see if you qualify for a court-appointed attorney. Once an attorney is appointed to you, that attorney must make contact on the end of the next business day. So for example, your attorney has already been appointed. That's Doug Campbell. He was appointed today. He will need to make contact with you by next business day. And I'll note that he's on the screen, so he's already made contact with you. Do you understand these rights?
Yes, ma'am.
All right, so what's going to end up having to happen, Mr. Campbell? Your client is going to need to come into the courtroom tomorrow so he can sign these rights that I've just gone over with him. And my understanding is that the agreement is for a PR bond.
That's correct, Your Honor.
All right, so I'll set the bond at $3,500, but I will grant a PR bond and waive fees. All right, Mr. Vasquez, we'll see you tomorrow so that you can sign the documents.
Judge, is it okay if I talk to my client at breakout?
Yes.
Thank you.
I'll send you to breakout room.
I'm in 4 already.
All right, Mr. Vasquez, if you can go to 4.
Okay.
Norma, when are we, Mr. Carrillo is excused, correct?
Yes, ma'am. Is he still on?
Yes, 14-9.
I'll call the judge.
All right, Sean Serene, thank you so much for your patience. Who's the attorney?
Judge.
Good morning. Who's the attorney you were working with?
Alexandra.
All right, are you all ready to proceed?
Just about. So I have 3 exhibits that I sent to Norma, and I do have, I don't know how to get videos to Brenna. Don't worry, I'm not trying to play all of them, but they might require, I might need to refer to them in this hearing. I'm not sure yet.
Okay.
I can do that in the moment, Judge, or I can just, however you want.
Yeah, let's go ahead and start. And
Okay.
then we do have, let me find it. We do have it where you can, what is it? What's the correct terminology, Brenna?
Screen share? File share or?
Yes, it's file share. Let me find that link.
I'm happy to share the screen. I'm also going to have to invoke the rule.
All right, we can put them in a breakout room. Doug Campbell, you still
They're all together, Judge, in one room.
Yeah, they're all in one room.
They're physically standing together.
Judge, I think everybody else that you sent to talk to the CLO are in that room still. So I'll just call my client.
No, I'll send you to number 5.
Okay.
Detective Jaime, can you have your officers go to different rooms, please? Thank you.
Okay, your client should be there. All righty.
Can y'all hear me?
Yes.
They might have to be admonished on the rule.
Okay, sure. I'll acknowledge them. That's not a problem.
Okay.
All right.
I sent them the opposite side of the station. My apologies.
All right, State, can you check to see if 2020 CR 3671 has been dismissed?
Sean, Norma forwarded me defense 1 through 3.
Okay, I had just started uploading them now. If I need to refer to the videos, I'll just, I don't know if the file's gonna be big. I don't know if I can just upload it here if I need to, just for the purposes of the record. But
we shall see.
Yeah,
We'll make it happen.
That's fine. There's really 1 is the main one, but there's 4 that I might refer to. Anyway, okay, I apologize. I just wanted to.
Judge, to answer your question about that case, I think Jure had submitted and the dismissal, is that the one he was talking about with Raymond? Yes. And that he said it was signed, but it hasn't been processed in the system.
Okay. All right, thanks. I just still had the file back here.
Yeah.
It was signed yesterday, Judge.
Okay, awesome. All right, and then just 1 second. And then on Vasquez, that's being recalled for tomorrow. And you filed a motion on this, Sean, or no?
I did, Judge.
All right, to the clerks in the back, can I get the motion on Spencer Banks, please? And it's a motion for discovery?
Yes, this is a 3914 compliance motion, I guess, for lack of a better word. What they have.
Oh, no, we're going to start. I just wanted to get the motion for them to give the motion to me.
Yes, ma'am.
All right. All right, the court is calling 2020 CR 5770, State of Texas versus Spencer Leroy Banks. Could I have parties announced for the record for the state?
Alexandra Williamson.
For the defense?
Sean Serene for Spencer Banks.
All right, and Mr. Banks, could you unmute for me, please?
It's the space bar, Spencer, if that helps.
I think you have to double click it. Here, you had it.
All right, click it 2 times, one more time, Mr. Banks.
The space bar, he has to hold down.
Okay.
There you
Yes,
go.
you got it. All right, are you Spencer Banks?
Yes, ma'am.
All right, we're proceeding with this hearing by video because of the pandemic. Any objection from the state or the defense?
No.
No, Your Honor.
Mr. Banks, do you have any objection to this hearing taking place by video? I'm sorry, we can't hear you.
You're muted again.
No, ma'am.
All right. So we are here on a motion for discovery and compliance. This motion has been filed by defense. State, are you ready?
Yes.
All right, defense, it's your motion.
Yes, Your Honor. Just generally speaking, the state has been having some, I don't want to say difficulty, but some issues with 3914 requests. So since a conversation that Ms. Williamson and I had prior to this hearing back in February, we have subpoenaed six witnesses from the Via Metro Transit Police Department. And so that's generally the nature of why we're proceeding today, is that they have been responsive to some degree, and there are some explanations that I think are necessary in others. And that's just to frame the motion, Judge.
Okay. All right, call your first witness, please.
Yes, Your Honor. My first witness will be Corporal Daniel Jaime.
Okay.
And I did invoke the rule, so I would like the witness and maybe witnesses to be admonished.
All right, Mr. Jaime, the rule has been invoked. What that means is you cannot discuss your testimony with any of the other witnesses. The only persons you're allowed to speak to are attorneys for the state or the defense. Do you understand?
Yes, ma'am, I do. Yes, Your Honor.
All right, could you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
All right, you can lower your hand if you'll state your name for the record, please.
Daniel Jaime.
All right, defense.
Yes, Your Honor. Good afternoon, Corporal Jaime. I appreciate your patience as well as that of your officers. Let me just ask real quick, they are not in earshot of this hearing or of this testimony, are they?
No, they are not. They have been instructed to step away from the door and proceed in 2 different directions.
Yes, sir. Thank you. Okay. And I just wanted to clear that up.
The door is closed and we're in an interview room.
So you are in a room all by yourself?
Yes, sir, I am.
Okay. Just for the record, where are you employed?
I'm with the Via Metropolitan Transit Police Department, San Antonio, Texas.
In what capacity do you serve?
I serve as a detective investigator as well as a shift supervisor.
And just so I'm clear and I address you appropriately, it's corporal, right? You prefer detective investigator or corporal?
It's people call me corporal, they call me detective.
Yes, sir. Are you considered the custodian of records for your police department?
Yes, sir, I am.
And that is not Lieutenant George Aguilar or Norman Longoria?
No, sir, they are not.
Okay. Your Honor, I had tendered defense exhibits 1 through 3 to Alexandra Williamson for objection. I'd like to offer them At this point, I don't know if there's any, I don't think there's any objection on authenticity.
Just, if he could put the predicate, that would be great.
So are you objecting to lack of foundation?
Yes.
Okay.
All right, Mr. Serene, if you would lay the foundation, please.
Yes. Okay. So to start off with defense one, so do you, is it your job as the custodian of records or in your capacity as a detective investigator to forward evidence to the Bexar County District Attorney's Office?
Yes, sir, it is.
And evidence in criminal prosecutions, is that right?
Yes, sir.
And let me see. So you would have personal knowledge over what is in their file system called Veripic.
I'm sorry, repeat the question. I did not hear that correctly.
Yeah, I'll ask a better one. Do you have any knowledge of their evidence file retention system, that's commonly referred to as Veripic?
I'm not familiar with Veripic, sir. I'm sorry.
How do you forward your evidence to the state of Texas, the Bexar County DA's office?
What I do is if it's video, I burn it from the body cam server, burn it over to a drive and submit it to the EIS evidence ingestion system. If it's documents, I do the same. I will submit them to a PDF if the system accepts them.
Okay. And so did you have a case, were you assigned a case for an allegation alleged to have occurred on March 27th of 2020?
Yes, sir.
Was that, and the defendant in that case would be Spencer Banks, my client?
Yes, sir.
You were not in the scene, you're not on the scene in that case, right?
I was not, sir.
But your job was to either review or collect all the evidence, audio and video and whatnot that existed on this case?
Yes, sir.
Okay. Did you review it and then refer it to Ms. Williamson's office with the Bexar County District Attorney?
I reviewed it and then submitted it. Yes, sir.
All right. Did you review and refer, what did you review and refer to their office?
Without having anything in front of me, I recall submitting several body cam videos and then a copy of a police report as requested. Yes, sir.
Let me see if I can share my screen real quick. Oops. All right. All right. And you see my screen?
Yes, sir, I do.
All right, I'm showing you what's been marked as Defense Exhibit 1.
Yes, sir.
Do you see the name Spencer Banks on there?
I'm sorry, you're moving it, so it's hard for me to see.
Sorry about that.
That's part of it. Yes, sir, I do see it. Yes, sir.
Okay. And as I scroll down, you see some descriptions involving an offense report, video, body worn camera. You see those descriptions and those file types and sizes. You see all those things?
Yes, sir, I do.
Okay, those are the things that you believe you had submitted to Miss Williamson's office?
Yes, sir.
Okay, so you have personal knowledge of what is in the state's file regarding this case?
I believe so. Yes, sir.
Okay, I'd like to offer for admission Defense Exhibit 1, pending objections from the state.
Your Honor, I do have an objection. Detective Jaime said that he has no knowledge of the district attorney's electronic evidence system. This is a screenshot of the DA's Veripic evidence electronic system, and he wouldn't have knowledge of that information. I don't know if this is an accurate screenshot. It could, I don't know when the screenshot was taken, and I don't think that the proper predicate had been laid for it.
All right,
let me ask. He's going to know that anyway.
All right, let me ask this question. The document states, I'm sorry, Defense Exhibit number 1. State, have you had a chance to review that document?
I'm looking at it, yes.
I mean, did you have a chance to review it before this hearing?
Mr. Serene did send this to me, yes.
All right, let me stop share screen. Mr. Serene, if you could stop sharing your screen, please.
Yes, Your Honor.
All right, let me see the state and the defense in a breakout room, please.
Sure.
If you all could go to breakout room number 2.
Norma, I sent you a message regarding Pena. Thank you. Corporal Jaime,
Yes, ma'am. Yes. Your Honor.
unmute for me, please.
It's
All right.
on-
Where is the other officer? The other officers who are going to testify?
We have Officer Chris Caballero.
Oh, where is he?
He's outside of the doorway.
All right.
Over there, I'd have to go into the other room and call out to him to come in.
All right. Can you call out to him and have him come into this room where you are?
Yes, ma'am. And that's Officer Chris Caballero or Officer John Martinez?
Sean, who do you want first?
Martinez and then Contreras.
All right. So if we could have Martinez first.
Contreras was not able to attend today. He was out of town. He was notified and he did not end up making it today.
All right. We'll get him.
For that, I apologize.
No problem. So if you could bring in the first one then.
That was Martinez first and Caballero, but you want me out when they come in, correct?
I don't need Caballero at this time.
Okay, just John Martinez, and I'll step out when he comes in, correct?
Yes, sir.
Yes. And
Understood.
remember, the
Thank
rule
you.
has been invoked.
Understood, ma'am. I will not discuss it with anybody.
Thank you.
Stepping out, ma'am.
And
I'm
Sean.
gonna leave it. I'm sorry, ma'am. I'll leave it unmuted. That way you can hear when he walks in.
All right, thank you. And Sean, with the other person you need, we'll make sure that they're available for you.
Thanks, Judge.
You're welcome. Sean, did you want your client in the breakout room with you? You're muted.
Let's just let's just be the attorneys for now, and I'll explain to Mr. Banks.
All right, Mr. Banks, your attorney will be right back, okay? All right, and I'm sorry, what is your name, sir?
My name is Officer Juan Martinez.
All right, Mr. Martinez, I'm going to send you to a breakout room with the state
Yes.
and the defense. The
Yes, ma'am.
rule has been invoked.
Yes, ma'am.
What that means is you can't discuss your testimony with anyone else that's involved in this hearing or anyone else, period. You understand?
Yes, Judge.
The only people you're allowed to speak to are attorneys for the state and attorneys for the defense.
I understand.
All right, so let me find you on the screen. I'm going to send you to breakout room number 2. And Sean Serene and Alexandra Williamson, if you'll go back to breakout room number 2, please. And everyone, we're going to stop live stream at the moment. And